Hello, welcome back to this A-level law video. Today we are going to be going through the topic of the jury. It is a topic in the English legal system, it is part of the sort of the lay people topic, and we're going to go through the content today. So I've got my notes on the side. Feel free to grab a piece of paper or something to jot down any notes with, and we are going to get straight into it. So there are four sort of points that we're going to be considering in this video today. We're going to look at, to begin with, just so we understand, I'm going to call it the key things to know. Key things. By the way, as always, this canvas will be made available to you on our website. You can download it on the link below. So we're going to look at the qualifications of a juror, but that also does include things like disqualifications, the ineligibility, and the excusals as well. We're going to look at the selection process. Okay, so how a jury actually gets selected. Selection process. We're also going to look at the role of the jury, what the jury does, the role of the jury, and then we also need to be able to evaluate, okay, so the positives and the negatives of the jury system, basically. So there are sort of four things that we need to know. Let's get straight into it. We're going to start off with the qualifications, okay, the qualifications of being in a jury. That's an awful line. There we go. Qualifications of being a jury. Okay, there are three or four, I should say, main qualifications. First one being, okay, the age range. So you have to be between 18 to 75 years old. Okay, it used to be 70. They did up it to 75. You've also got to be on the electoral register. All that means is that you are eligible to vote in the UK at any elections. You also have to have been a UK resident or residing in the UK since 13 for 5 years. 5+ years. Okay, obviously taking you up to 18. And the final one, which is kind of obvious, but it's always good to mention when we're talking about if you're ever given it in an exam, like a 10 marker or an 8 marker, depending on which exam board you do. And by the way, I should preface this is for OCR, WJEC, and also, I always say it, but AQA as well in some cases. AQA check the specification. What I found is that OCR and WJEC are quite similar. So the final thing on the qualification side is that they are obviously, they're not disqualified. They're not disqualified, excused, or ineligible. I always forget this word. Or ineligible to serve on the jury. All right, I'm just going to scroll down on my notes. Then we move on to our sort of the disqualification process. So we're still in the qualifications section. We're just looking at the disqualifications. Disqualifications, okay? So first thing to note is that you are disqualified for life if you have received a sentence of 5 or more years. Okay, and that's usually like a prison sentence. So that's the point blank for life. Okay, you receive a disqualification of 5 years. Okay, if you've had, if you have had a sentence of less than 5 years, or sometimes it's also referred to as any other sentences. And the final bit for disqualification, which is good to note, is if you're on bail, and that's going to be for the duration of bail terms. Okay, so however long the bail is going on for. Okay, so those are your three main factors to consider when we're looking at disqualification. Okay. What about the ineligibility then? Ineligibility. Definitely spelled that wrong. So the Criminal Justice Act of 2003 mentions people, persons, I put people's there, people suffering with a mental disorder. Again, awful line. A mental disorder. And I'm going to call it the CJA of 2003. Obviously, CJA, Criminal Justice Act. The next one, people or persons, as it says, lacking capacity, lack of capacity. Okay, so what that means is that they would basically be unable to uphold the job of a juror, and you could use examples of things like non-English speakers, or perhaps someone who has, obviously as sad as it is, a disability. So if they're blind or deaf as well, that would be a reason, obviously, that they would be ineligible for jury service. So that's something to consider. All right. So those are your two ports of call if you are when you're looking at the ineligibility. And don't forget, these four things, so the qualifications, disqualifications, the ineligibility, and the excusals, which is what we're going to move on to, they can all be part of the same answer for example, if you're asked, describe the qualifications that are of a juror that is appointed to jury service or something along those lines, you can discuss all four, because it's never only just going to be about they need to be 18 or to 75. They need to be on the electoral register, not disqualified. That's not going to give you all the marks. So it's important you talk about all four. Okay. So let's have a look at excusals now. Okay, excusals. So not complete ineligibility, just something that may be pushed back. Okay. So the first excusal, or the type of excusal that we normally talk about is a discretionary excusal. And that can be a plethora of things. It can be things like the birth of a child. Sometimes for 18-year-olds, exams. It's very possible it's happened in the past. You've also got things like if you're the sole, okay, keyword being sole, so the only carer of a person. And believe it or not as well, what's the word? Probably not business meetings. That's the word. Business meetings that can't be rearranged. Okay. And also, in the Criminal Justice Act of 2003, you can no longer, because it used to be the case that sometimes certain professions would be sort of let off from jury service. But the Criminal Justice Act of 2003, that basically said no matter the profession, so like doctors, judges, lawyers, they still had to attend jury service. They can't be excused, basically. So there's our little canvas for the qualifications of basically someone who is in the jury. We're going to move on now, and we're going to look at the actual, scroll down on my notes as well, the actual selection process. So the main selection. All right. So how it works is, again, remember, they've got to be on the electoral register. Something called the central office computer. So the central office computer randomly generates names from the electoral register. Okay. And usually what happens is they'll be sent to summon to the Crown Court. Whilst we're here as well, actually talking about the Crown Court, remember our court's hierarchy. So a jury never sits in the magistrates, only ever in the Crown Court, and they will hear indictable or indictable offences or either way offences, triable either way offences. Separate video on that, obviously, but obviously your indictable offences are your most serious criminal cases, and then your triable either way offences, they will typically hear, obviously the only ones that go up to the Crown Court, the ones that are serious or tip over the scale, I call it a scale, tip over the scale to being, you know, quite complex, or there's something that needs to be discussed. So they'll only ever hear, there'll only ever be a jury in the Crown Court. Okay, so when they're sent summons for the Crown Court, I'm gonna pop this in a different colour actually. The fine is actually pretty hefty. It's a £1,000 fine, or at least it was at the time of making this video. If you don't turn up, if you don't show up, all right. And like I said, it's quite serious. Jury service is seen as, you're like what they call a duty to your country. Many people describe it as a jury to the country, a duty, sorry, to the country. So again, it is serious, and the laws around it, as we'll go to see on later in this video, quite serious. The jury or the selected candidates will watch some training videos for like guidance, and also instructions. I'm sort of just giving you the basics that you need to, the content that you need to know. They are also based in a jury pool, so there's multiple people based in a jury pool, which after that, 15 names are read at random. And after which 12 randomly are selected. And the other 3 are reserves. Okay, so if anything happens to any of the 12 jurors that are selected, the other 3 can step in. All right. So the process is obviously then going to be that they need to go through vetting checks, if necessary. Then obviously it can also be challenged, or challenges can arise, which we'll talk about in this video as well. And then obviously the jurors will then be sworn in, so they'll be under oath. Again, laying down their basically their responsibility as jurors in a case. Let's talk a little bit about vetting and the challenging. So there's a couple of points for each. And there's also some cases that I like to talk about when I discuss them. So vetting, okay, these are sort of like your initial checks. Now, in the case of, and I'll pop them in blue, any cases, R.V. Mason, okay, R.V. Mason of 1980, or this case sort of established that routine, keyword routine, checks can be done to ensure that a juror is not disqualified. Okay, is not disqualified. We don't need to know a whole lot about the case itself. That's just what it established. And then you've also got cases where wider checks can be done for things like political affiliations, This is very rare though, and it can be quite a long process because you actually need permission from the district attorney to do that. From the Attorney General, sorry. The district attorneys are American. You need permission from the Attorney General, so it should be AG, to do that. Again, making it a long process. So yeah, that's the 2 points that you need to remember for vetting. The general checks, which can be conducted to make sure that a juror is not disqualified, and then the wider checks, which is not often done. Yeah, it's very rare indeed. You've also got the challenges, okay, and we're not talking about like hardships or anything. What we're talking about is the challenging of the jury. Okay, so there are sort of 3 types. So you've got a challenge to the array, and basically what that is that challenges the way, okay, the process the jury was selected. Okay, the way or the process that the jury was selected. For example, it could be that there's a bias, or there is it's unrepresentative. This is seen in the case of R v Ford. Okay, R v Ford. There's no date actually attached onto my notes, but I don't think it's a very it's an important case for this topic. But basically, what they were arguing was that it was an all-white jury, but they obviously said no, that's not reason for a challenge, because the selection is meant to be random. So the selection is totally random. It was just a chance. It was literally just chance that it happened to be an all-white jury. You've also got challenge for cause. And that is challenging a person's right to be in the jury. So a right to be in the jury. Okay. And the final one is one that's only available to the prosecution, but it's the right of standby jurors. Right of standby. The right of standby jurors. And again, it's only available to the prosecution. And what it does is it allows a member of the jury to be put at the end of the list. Okay. Allows end of the selection list. Okay, and again, that's only available to the prosecution. Only available to the prosecution. Okay. Now we're going to be moving on to having a look at the role of the jury. Okay, the role of the jury. We've looked at a breakdown. We sort of discussed the vetting process and the checks that can be done. So what does the jury actually do? It might sound like a simple question, but they always chuck questions like this in, and it's important that we know the content. Okay. So we've already had a little discussion about this, and we've already said that juries will only ever be in the Crown Court. They'll only ever be in the Crown Court hearing indictable or triable either way offences. All right, they're not going to be in the Magistrates' Court. The Crown Court is where they will be located, and only if the defendant has pleaded not guilty. Okay, so they have said an accusation has been brought upon them, and they have said, "Oh no, I didn't do it." Okay, so that's what plead not guilty means. All right. So the Crown Court, and I'm just going to make a note under them in red. They will hear summary offences. Can't spell today. Summary offences or triable either way offences. Okay, That's our sort of the location of where they're based. Now, there's always a group of 12 in the jury. 12 in the jury. If you wanted to make that sound a little bit more legal, you can say always sit as a panel of 12. I'll put that there. A panel of 12. And as we discussed in the vetting and the sort of the appointment of jurors, there's always 3 reserves as well. Okay. And a very important act that you need to know about as well, we're going to pop it up at the top tier, the Criminal Justice and Courts Act of 2015. Okay, the Criminal Justice and Courts Act of 2015. And what this act does is it makes it an offence, okay, an offence to intentionally disclose, is the literal wording, intentionally disclose or ask, very big one about ask as well, or ask anything about what happens in the jury room, anything that happens in the jury room. Okay, and the reason I make emphasis on the word ask is because this is all the more important for those in the press. Okay, so for example, you will never, unless it's like exceptional circumstances, the press will never ever go up to the jurors and ask them what they discussed, because it's a criminal offence in the UK. They can actually be in a lot of trouble for it. All right. Now, the other part of it is obviously what role the judge plays, okay? Because the judge sort of plays an intertwining role with the jury, and what the jury do is their description of the work is that they will weigh up, or they must weigh up, okay, the evidence. They will weigh up their evidence and the facts. Okay, that's another important one. And the facts before they give their verdict. Okay, the verdict we'll go on to discuss now is their decision, or the choice that they've made. Do they find the person guilty or not? And what I was saying about the judge, okay, we'll go on to see how judges don't really have sort of control over the decision that is made by the jury, but the judge will sort of advise or direct the jury on points of law. Okay, because don't forget, the jury is randomized, so not everyone is going to have a legal background. They're not going to have, you know, the expertise per se. So they will advise and direct the jury on the point of law, and also and deal with the sentencing. Okay, so the jury don't deal with the sentencing. They just give the verdict on whether someone is guilty or not. They deal with the sentencing side. The judge deals with the sentencing side of things. Okay, let's move on to the verdict now. So still part of the role of the jury, but obviously the verdict is the decision that they make. Is the person guilty or not? Now, there are 2 types of verdicts which we typically tend to look at. Okay, and the 2 types of verdicts that we discuss are majority verdicts or unanimous verdicts. Now, a majority verdict is going... but let's start off with unanimous. That's usually the easiest one to talk about. A unanimous verdict is where all the jurors agree. Okay? So there's no disagreement between any of them. They all have the same opinion about whether this person should be found guilty or not. A majority verdict, this is where things get not complicated as such, but they can be a little bit different. So a majority verdict will sort of be accepted after 2 hours. So typically it's a 2-hour deliberation, 2-hour discussion, I'll call it. Deliberation makes it sound like it's an exam. A 2-hour discussion. The judge can then accept a majority verdict. Now, this is where we're sort of getting into the trickier side of things. So when we say a majority, okay, we're not talking about like 7 to 5. That's, although obviously it's still a majority, we need to have a little bit more than that. So the minimum that the judge will accept is 10-2. Okay, so if it's 11-1 or 10-2, the judge will accept a majority verdict. Now, the problems arise where obviously the jury isn't agreeing, and so after after discussion, and if a decision can't be reached, then, for example, anything below a 10-2, so a 9-3, for example. Again, the figures are still high, but it needs to be, the minimum is a 10-2 for the judge to be able to accept a majority verdict. What can then be done is that the jury will be declared hung. Okay, so the official term is a hung jury. A hung jury, which means they couldn't come to an agreement, and then a retrial is issued. Okay, a retrial ordered. I'll say a retrial is ordered with, key point, with a new jury. Okay, so they'll have different people. All right, and that, I'll pop that in green. Actually, that's an awful circle. I'm gonna circle it because it's important to remember. This only happens when a majority cannot be reached. Okay, only happens when a majority cannot be reached. And one small point to point out as well is that the jury will never they never give reasons for their decisions, okay, and the decisions are always made in secret, which is what we'll go on to look at the positives and the negatives now, or the evaluation of the jury. So, in terms of the evaluation, well, what I've sort of done is I've got about 4 for each one. And there's certain cases that you can use as well to discuss about the evaluation. Okay, so let's start off with sort of one that is the easiest to remember. Okay, and that is that the jury. Okay, the jury have something called jury equity. Okay, jury equity, and what that means, they're allowed to make make the decision, or they're allowed to make the verdict is probably a better word, based on fairness, rather than what the law says. Okay. And a very good example of this is the case of Ponting. Okay, this was discussed briefly in the one of the past paper questions that we went through for, I think it was the 2024 paper. But it will be the case of R.V. Ponting of 1984. Okay, and this is a very famous case because this happens during the Falkland Wars. Okay. And it included Argentina and Britain, and there was a sinking of an Argentinian battleship, and that wasn't like active. It wasn't gonna fire or anything. And Ponting was I think he was like a civil servant or someone of importance. And what Ponting did was he basically told the public, or I think he leaked it to the newspapers, that obviously the British had sunk on this harmless Argentinian battleship, and Margaret Thatcher was absolutely furious. She was fuming, and what they tried to do was they tried to charge Ponting under the Official Secrets Act. Okay, now because basically what he had done was, well, it was against the law, but the jury acquitted him, so they found him not guilty. They found him not guilty because they said, well, really, it was more of a matter of conscience. He saw that what they did was wrong, and rather than keeping a secret, he told people. So this is what I was also saying about the judge. The judge was very biased. I think there were certain points where the judge was very much trying to convince the jury that he was in the wrong, but it didn't matter because the jury made the decision to find him not guilty. Okay, so that's the case of R.V. Ponting. Now, on sort of track with jury equity, that does also mean, okay, so I'm going to sort of draw on each point because they've each got their own negatives. That does also mean that that perverse verdicts are reached. Okay, perverse verdicts are reached, which means that legally speaking, on paper, the defendants should have been found guilty. Okay, should have been found guilty. Okay, and it's similar to the case of Ponting. Really, he should have been found guilty if the jury was sticking to what the law says. He was in breach of an act that the government had made to not expose information about the government in any way, shape, or form, which he did. But they found him not guilty. So perverse verdicts can be reached. All right. Another one is that positive is the whole premise of sort of the democracy behind it. Okay, the democracy. Others call this public confidence. Public confidence. Okay, and this goes all the way back to the Magna Carta. The Magna Carta. Okay, trial by one's peers. Okay, so you've got other ordinary people looking at the situation and, you know, saying you were guilty or not. Okay, and generally what we tend to say is that the public is satisfied. The public is satisfied with the jury verdicts, with the jury trials. I'll say jury trials. Okay. Unfortunately, the downside to this is what we call jury nobbling. Okay. Now, this is actually a sort of, I don't want to say slang, but it's like a what's the word? I don't know what you call it. Informal way of jury tampering is the correct term. Jury tampering. Okay. Now, there's a case that we obviously jury tampering with a jury, getting the jury to paying them off, you know, anything that would involve infiltration of another source, trying to get into the jury's mind. Now, there's a case that we use for this, and that is the case of here we go. I'm trying to see if I can say the surname. I've got it on my notes. R.V. Twomey and others, I think it is. That's how you pronounce it. Twomey and others. And that's actually pretty recent. It's 2009. Okay, so the facts of this case, if I can scroll down, the facts of this case are that there was an armed robbery. Okay, so an armed robbery at Heathrow warehouse. Okay, Heathrow warehouse. And the figure, the sum of things that were stolen was massive, £1.75 million. Okay, and that included, you know, loads of different things that were stolen. But the defendants were being tried under a couple of things, including robbery and a firearm offences. firearm offences. Now, there were actually allegations that the jury had been tampered with. So the prosecution actually looked to see if they could get a judge-only trial. Now, this is extremely, extremely rare. It never, ever happens, you know, in terms of cases like this, where it is so big they need to have a jury. And initially, it was actually refused. So basically the judge had said, oh, well, why would you do that? You need a jury. But they appealed. And what happened the second time was that there was a Chief Justice, and they said that the estimated, okay, I'm going to note this down actually because it's quite big, the estimated £6 million, right? £6 million, and over 80 police officers to protect the jury would have been unreasonable, which is very true. It's a lot of money and it's a lot of police officers to protect the jury. All right. So what they did was they moved the trial, and obviously the defendants were convicted. Now, the reason we talk about this case is because, can you see how even the accusation, so it could not have been, to this day, we don't know what happened exactly, but to this day we don't know whether the jury was properly tampered with. We don't know if there was anything that was snuck in. However, as we discussed in the, if I've not already mentioned it in this video, I've mentioned it in a past paper, we always think about, I think it was Lord Devlin who said that justice must be seen to be done, because let's say, for example, they hadn't switched to a judge-only case, and they'd continued with the jury, and if they were acquitted, or they'd continued, and even if they did find them guilty, what would that have done to the public's perspective of the jury system and the legal system as a whole? So this is where they've got to be really careful and think about all the possibilities that could come up against them. Okay, and we sort of go into that about, we go into this a little bit more detail when we look at judicial precedent. Okay, obviously nothing to discuss in this video, but when we look at why judges have to follow previous rulings, or why sometimes they've got to be careful in terms of what they basically make precedent. Okay, so we've discussed, I think we've got one, two, we've got two more to discuss now. The second one is that there's obviously the secrecy behind it. Okay, so the secrecy of the jury room. Okay, it's in totally what's the word I'm thinking of? Sort of out of the public. I'm going to say totally out of the public eye. We don't know how the jury reached their decision. Okay, they don't have to tell us how they reached their decision. And that also means that there is less things like unpopular or popular verdicts. Okay, less unpopular verdicts, which means they're free from that influence of the outside. Rather than trying to please other people, they're looking at the case themselves. And because nobody knows what's being said, and because nobody can say what's being said, that's how they're able to get to this, the decision that they get to. But that also means that there's sort of a two-sided coin here, because that's also a negative. So we don't know how they reach the verdict. We don't know how they reach the verdict, and that is a very quite a daunting thought, actually. I'm just scrolling down now because there is actually a case that we can talk about, the case of R.V. Young. R.V. Young. Okay, and this, I always, when I was studying law, I always thought the nickname I gave to this case was the Ouija board case. Okay, Ouija board case. The reason it's called the Ouija board case is because in this particular case, the verdict was so difficult to get to that the jury had to sort of break away, and they were given more time to think about it, and they were put in a hotel room where they were outside of public view. Now, the problem with this was that it came into light later. The jury actually ended up finding the defendant guilty. It was for a murder trial. But it came into light later, I think it was a couple of days later, that I think it was 3 or 4 of the jury members had gotten together and tried to use a Ouija board to communicate with the dead to figure out if this person was actually, if this person had been murdered by the defendant. Okay, and the reason that they called this they had to call the jury back and say, listen, you broke the law or whatever, because, all right, they were using, first of all, outside sources. I know obviously everyone has their own opinions about spiritism and whatnot, but they're using outside sources, and also, again, justice must be seen to be done. 3 or 4 of the jury all had the same belief in not ghosts, in spirits. And I know it sounds silly to say, but something as small as that can definitely affect the way that the jury is seen. And even if obviously that eventually ended up going out into the public, again, what will the public have thought when they saw multiple jury members, when they all believe in the same thing? All right. And the final one that I want to sort of discuss about now is that the jury system is open to the public. Again, there's that whole thing about it being trial by one's peers. Okay, so it's what we call an open system of justice. An open system of justice, which means that anyone, obviously providing that they're on the electoral register, 18 to 75, they're not, banned or whatever from being in the jury, anyone can be asked to go to jury service. Okay? It's open to anyone in the public, again, providing that they're properly, properly enrolled, I suppose you could say. But because there's also it's open to the public, sometimes it also it means that judges do have to simplify the law so that they can understand it. Okay, so there is that little bit more clarity with people who don't have any legal experience. And the downside to that is obviously the lack of understanding, unfortunately. Okay, the lack of understanding with certain jury members. You could have a jury member who, is not making sense of things. They're eligible to be on the jury, but they don't understand a thing that's going on. Obviously they're trained a little bit, they're given video and directions, but again, not everyone understands that. And one good report to quote is it's a little bit older now, but there was a report by I think she was a journalist, Cheryl Thomas, in 2010, and it was called Our Jury's Fair. Okay, and that was by Cheryl Thomas. And what this sort of did was that it showed a little bit of insight into it. And she used simulated trials because she couldn't use real ones because it would obviously been against the law. And she found that only 31% of the jurors, so people that she had picked at random, were actually understanding the directions that were being given to them. Okay, 31%. Obviously, we don't know. We don't know like how many people she asked, but it's still obviously quite a low number. Jurors understood directions. Okay. So that's sort of that's really the jury topic kind of covered. I think that's everything that we need to go through, according to my notes as well. So obviously there's quite a bit here. This is obviously going to be made available to you again on the website. You can have a look at the link below. Always, these mind maps are always free. You can download them from our website. So we've had a look at the jury, we've looked at the qualifications, the sort of the main selection of the jury, the vetting process, the roles, and also we've had a little bit of a look at the evaluation as well. So I hope you guys have found this video helpful. If you've got any questions, leave them down below. Don't forget to like and subscribe to the video. That would help our channel out massively. It helps us to be able to produce videos like this. You know, we don't make any money from this channel at the moment. Maybe we will in the future, but it helps us to create these videos and gives us a little bit back for, you know, the time that we do spend on the resources, on the equipment that's used to make them. So if you guys let us know what you thought, that would be brilliant, and hopefully we'll catch you guys in the next video. Thank you so much for watching. Take care. Happy revising.